Hello, this is Matt on the Moon Lambo channel. By now I'm assuming that most of you have heard the news that the SEC has filed a request for appeal. And I went in depth on that as much as I could at the time. The story was breaking, so I started recording probably roughly 2 hours after the news broke. But I covered the key components to that. So you can go back to my last video if you want a bunch of specifics, but there was one part that I was fuzzy on, and I promised at the end of my video that I would come back and get an answer for you. And I do have an answer for you. And what I was questioning was, although obviously so the status of XRP itself ultimately is not going to be a concern. I got that from multiple attorneys in the XRP community, so I never doubted them. I got that from, just for instance, John Deaton's crypto law organization, Attorney Morgan and Attorney Hogan, all saying the same thing. This is not something we need to worry about in terms of the appeal, should it go through, which also isn't a guarantee that it will. It wouldn't impact the legal status of XRP. But there was a question mark that I had, and I wasn't the only one that had this question mark, and I ended up getting an answer, which I'll share with you at the beginning part of this video, actually. But I was wondering, okay, the SEC, what they're going after here, as articulated in the filing to Judge Torres, in a big part of what they're going after was programmatic sales of XRP. And I said, well, wait a minute, but programmatic sales, you're talking about secondary market transactions. The transactions where people like you and I might buy XRP, right, on cryptocurrency exchanges. So if they won an appeal, would that impact us? And so I already knew that the answer was no, and so I trusted them, but I didn't have the why part of it. I trusted them because these are, to have multiple lawyers agree on that, a gigantic point. I wasn't doubting it, but as I cited in my last video, I don't know the why part of it. I don't know why that wouldn't be. And since it was developing, I hadn't had that part figured out before recording, but I did get clarity. So I have perspective from John Deaton's crypto law organization, Attorney Morgan, and Attorney Hogan in this video. And you know what the good news is? As it turns out, Judge Torres, she's never had a single one of her decisions overturned by a higher court. Not once ever. Now that I don't think I had ever heard before. But Attorney Deaton had some stuff to say about that, so we'll cover that as well. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. I'll tell you, though, would Judge Torres having never been overturned, would this be the moment it actually happens? Would this actually be it? She judges in such a way that she's made herself appeal-proof so far. I have a certain level of confidence. We'll see what happens. But anyway, as to what it would matter for XRP holders, I don't think it would really particularly matter, but we'll get into that part a little bit later. Let's start with the more pressing issue, since it's on the latest development having to do with the fact that the SEC, again, has filed a request for appeal, which is separate from an actual appeal. They have to file a request because the case isn't over here. So it would be an interlocutory appeal, which is basically just an expedited appeal, but you're not guaranteed that. You're not owed that. You can just request it. And I don't think that Judge Torres is going to actually approve this thing. But here's what Attorney Hogan had to say earlier today, and this part I covered, but this is where the update kicks in. So here's what Attorney Hogan said earlier today when the news broke. And I say today, it's after midnight, so technically yesterday, but I haven't gone to sleep yet. So and I'll get this video up as soon as I can. But anyway, he says, and the SEC continues making questionable decisions, requesting an interlocutory appeal. Note that it is not appealing whether XRP itself is a security, just its losses on the programmatic and individual sales issue. And so again, that's where my question came in. I said, okay, well, so XRP itself, according to multiple attorneys, including Attorney Hogan, and I certainly trusted them as I cited in my last video, XRP itself, not a security. That's not something that the SEC is trying to have altered in any sort of way. And they really wouldn't be able to, because frankly, it's the term that I've seen used to describe it is dicta, D-I-C-T-A, which means it's something that the judge opined on, and to some degree it was connected to certain final conclusions in a way, but more importantly, actually, as far as I can tell anyway, it was something that was brought up because of the broad, bogus, nonsense assertions the SEC brought forth having to do with the embodiment theory, that XRP is the embodiment of all Ripple's efforts, so on and so forth. You know the whole spiel, right? So that is not something that the SEC actually can appeal, because it's not something that was ruled on. It's just something that was put down. But even though that's the case, it's just fascinating that that still is the law of the land, despite it just technically being dicta, apparently. But I was wondering, okay, so again, it says, all that's being appealed here is programmatic and individual sales issues. So the programmatic part is the one part that made my ears perk up. So I wrote to Attorney Hogan and I said, the Torres ruling on XRP programmatic sales is what led to XRP being a non-security and cryptocurrency exchanges relisting XRP. Isn't challenging programmatic sales the functional equivalent of challenging the non-security status of XRP? I need an adult. And then I put a little laughy emoji because, look, it had been a while. We're approaching a month since this ruling here. And so certain aspects of the case, admittedly, were not as clear as they were on, for instance, July 13th, when this came down, and July 14th, when we were still really getting into the nuts and bolts of this thing. And so part of what I wrote there is actually incorrect. When I wrote the Torres ruling on XRP programmatic sales is what led to XRP being a non-security, that's actually not quite right. What led to XRP being deemed a non-security was on page 15 of that ruling. And then separately, on page 22, that's the section where Judge Torres began her decision-making on the programmatic sales. It was a completely different section, actually. So it's a nuance, but I did want to mention that. But that's the part, on page 15, where the final decision was made, and then we have programmatic sales separately. But still, I needed clarity, because even setting that small mistake aside, I still wanted to understand, okay, well, programmatic sales, what's going on there? Attorney Morgan responded to me and said, no, it is not. What many missed in the Torres decision was not just that she found XRP itself was not a security, but that she referred to the SEC v. Telegram case, amongst others, and found digital assets such as the Gram token are commodities. And so I appreciate that. Thank you very much, Attorney Morgan, although I still had my question because I wanted to understand, what does this mean for participants in the cryptocurrency space like you and I that might be buying XRP on cryptocurrency exchanges? That's what I'm trying to get at. If the SEC were successfully to appeal programmatic sales, what does that mean for us? And I still didn't quite have that answer. Attorney Hogan also wrote to me, and I do appreciate this as well. He wrote, 2 separate issues. XRP is not a security, period. But if the SEC wins the appeal on sales, then Ripple couldn't use exchanges to facilitate sales. And the big question, would exchanges keep XRP listed? I think yes, as long as they can verify the sales are not being made by Ripple. And so that makes sense. So the good news is he doesn't think, like, even if it went that route, he doesn't think that XRP is actually going to get delisted by Coinbase and pick your cryptocurrency exchange. But it would be interesting, because Ripple couldn't engage in programmatic sales even of XRP at that point, which is what Judge Torres said is actually A-okay. And so I appreciate that very genuinely, but that still didn't quite answer my question of what's the impact for us. I was trying to find out what happens regarding programmatic sales. And I think part of the reason that I wasn't getting the answer I was looking for is because, as it turns out, the simple answer is, and I'll share with you Crypto Law's answer, the transactions that were ruled upon by Judge Torres were from Brad and Chris and Ripple and don't apply to anybody else, more specifically. And so that's what I was trying to understand, because I want to understand what is this. So if the SEC is appealing programmatic sales, and we have broadly been stating within the XRP community that programmatic sales are safe, secondary market sales as a result of the ruling are safe, what does this mean? And so that's the part where I was seeking clarity. And I think a lot of you out there listening were also kind of wondering, what does that mean? And so then we get to John Deaton's Crypto Law account on X, formerly known as Twitter. And I don't know if this was John Deaton typing, or if he just has some of his employees from his team running this account. I don't know. Like, when I've been watching live streams from John Deaton's Crypto Law YouTube channel, I know that he's got people running it at that time, because I've been in during some of those live streams and I'll just say, hey, or comment this or that. And the Crypto Law YouTube account has written back while John's speaking live. So I don't know for sure if this was from John Deaton or if it was just somebody from his team, but either way, I got the answer. And so here is what John wrote. Judge Torres did not rule on all programmatic sales of XRP in the whole world. She specifically noted that as a way to make clear she was ruling on the SEC's specific allegations about sales by Ripple, Garlinghouse, and Larson. Thus, she did a strict Howey analysis of those sales, and that's all the SEC is essentially left with appealing. And then I think there was a misunderstanding because Crypto Law also wrote, Matt is making a leap that is not the decision. And it's kind of funny because I was actually mentioning in my last video, I was trying to be crystal clear. This is before I'd read any of this stuff. This didn't even exist at that time. I said, just to be clear, me asking questions is not me disagreeing. This is me seeking to understand. So I think whether it's John or somebody at Crypto Law, I think they thought that me asking these questions was me disagreeing. And sometimes people, when they ask questions, it is because they disagree. That was not the case here. I was just seeking to understand whatever's going on because I'm not the attorney. But that did answer the question. And you can see my responses on the screen. I don't feel it necessary to read all of this other than the last post at the end of my thread, in which, after in part thanking CryptoLaw, because I really appreciate the response, and it did result in clarity for what's going on here, I ended up writing, in case anyone is still confused, the most key point, as explained by CryptoLaw, the Torres ruling on programmatic sales only applies to programmatic sales transacted by Brad, Chris, and Ripple, not any other programmatic or secondary market transaction by you and me. So think about it this way. If the SEC wanted to come after, anyone like you and I, they'd have to go after you or I or anybody purchasing XRP on cryptocurrency exchanges and make assertions, and then you'd have to have a whole new litigation. Can you imagine that with just an individual? I wonder what the optics of that would be like for the general public. And then you'd have to apply the Howey test to that. Investment of money with the expectation of profit. The whole thing, and common enterprise and all that. So no, that would obviously not pass the Howey test. And so the way that Judge Torres was speaking in her decision, she was also talking about blind bids and stuff like that. So she understands, even if not as broadly stated, because she didn't make a blanket statement technically about secondary market transactions. I understand that. But if you look at the types of things that she was writing, I think it's pretty clear she understands that if it were transactions like you and I just blindly buying from we don't know who, but on a cryptocurrency exchange, of course, that's not an investment of money into Ripple or any sort of common enterprise. Duh. It's very clear that she understands. So anyway, thank you, Crypto. I don't know if that was John or somebody else from his team, but whoever that was, thank you very much, because that did finally provide the clarity that I was looking for. And so now I'm able to share it here, as I promised I would on X. And so to top this off, the good news is Judge Torres has done a fantastic job of making sure that when she rules, what she puts out there is appeal proof. And not that it literally is, you never know for sure, but what a track record she has. So take a look at this. Here's the headline. The top lawyer says Judge Torres' decision has never been reversed on appeal. U.S. District Judge Annalisa Torres' decision in the SEC v. Ripple lawsuit has been a major topic of discussion. Recall that she ruled that the company's institutional past sales constitute investment contracts and found that programmatic sales on digital exchanges are not securities. As expected, several legal experts have slammed her decision in the case, including U.S. District Judge Jed Rakoff, who rejected Judge Torres' distinction of Ripple sales. So I'll pause just as a friendly reminder. Judge Rakoff is the judge ruling over the Do Kwon case. That's the Terra case, with Terra Luna and the whole collapse from May of last year that set the entire crypto space cascading on down to dire levels. With the final capitulation in November of last year as FTX ultimately collapsed because it turns out that was a Ponzi scheme. Who saw that coming? That whole thing. So the Ripple case was cited in that case, and Judge Rakoff, I don't want to go through the whole thing again. I've covered it pretty thoroughly on the channel in the past. But he seemed to think that part of what Judge Torres said, including having to do with programmatic sales, didn't make a damn bit of sense. That's his perspective. But what's funny, in part, is attorney James Murphy, who goes by the name Meta Lawman on X, formerly known as Twitter, before the decision or before that comment came down from Jed Rakoff many, many months ago, before we even had the ruling from Judge Torres even, attorney Murphy said that Judge Rakoff was a, quote, renegade judge, end quote, and said that this is a judge within this district, the same district that Judge Torres is in, who likes to disagree with his fellow judges. He's a renegade judge. That's the term that was used. We didn't know for sure that he would ultimately come after the Judge Torres' decision, but he did. He just likes to do that stuff, apparently. Renegade judge. So how about that? And he's got a bad record in one way. We'll see. Let me go a little bit further. Piece continues. Consequently, growing speculation is that the Second Circuit will reverse Judge Torres' decision. Reacting, crypto law founder John Deaton expressed confidence that the Second Circuit will not reverse Judge Torres' summary judgment decision. Quote, I am extremely confident that her decision is untouchable on appeal. End quote. That's directly from Attorney Deaton. Piece continues. Attorney Deaton remarked a recent Twitter Spaces hosted by Uphold Cryptocurrency Exchange. According to Deaton, Judge Torres has never had her summary judgment reversed on appeal. Attorney Deaton, check this out, and this is amazing. So just this comparison, this is so fun. Again, Torres never has been reversed upon appeal, but check this out. Attorney Deaton added that Judge Rakoff, who criticized Judge Torres' reasoning in the Ripple lawsuit, has been reversed 56 times by a higher court. Woo! And the Bitcoin maxis would have you believe that this is the most sound reasoning, Judge Rakoff, the ultimate. No, as it turns out, definitely not. It sounds like just a troublemaker, and he's probably not good at, reasonable rulings from what it seems. Reversed 56 times compared to 0? I'm going to side with Judge Torres on this one, just going to say. Piece continues. Furthermore, Deaton explained that the SEC was responsible for distinguishing XRP sales into 3 categories: institutional, programmatic, and other distribution. Since the SEC alleged that these sales were investment contracts, the judge strictly applied the Howey test to them. Quote, this is Deaton again. The Howey test says it is immaterial whether the underlying asset is speculative or has intrinsic value. Are these Howey factors satisfied? She went and applied them to each one, XRP sales, and found what she did. End quote. Interestingly, Attorney Deaton reiterated that he is willing to place a massive bet that the Second Circuit will not touch her decision on appeal. Quote, this is Deaton again. I'm willing to put a huge bet that her opinion does not get touched on appeal because all she did was apply that law to those different types of sales, and the results are the results. End quote. Yeah, and I think that makes a lot of sense, and I have mentioned that on the channel before. And the language she used, it was even the language that the SEC was using. In terms of institutional sales, programmatic sales, Judge Torres didn't come up with that. She was asked to rule on these things, and she ruled on these things by applying the Howey test. She just did her damn job. Piece continues. Meanwhile, top members of the XRP community took to X, formerly Twitter, to react to Deaton's latest remark. Pro-XRP lawyer Jeremy Hogan joined other XRP enthusiasts in reacting to Deaton's comment, saying, quote, it is almost unheard of, end quote, that Judge Torres has not been reversed on appeal. And then he said, this is also a quote from Hogan, that's like getting straight A's from elementary through post-grad. Getting straight A's from elementary through post-grad. Like not even an A- in calculus, end quote. Spot on. So no, I'm not worried about any of this. And even if the SEC went on appeal, they're not trying to get the status of XRP flipped because they can't. So it doesn't matter anyway. All that would happen, even if they won on programmatic sales. I guess you could kind of theorize about what impact it might have for broader crypto markets or what other projects might do this or that in terms of legal strategy. Might change the temperature in a room in theory. But it wouldn't change the legal status of XRP, and again, Attorney Hogan doesn't think, and I can see why, doesn't think that it means that exchanges would, delist XRP again. That would make any damn sense. Because, again, even if they win an appeal on the institutional and programmatic sales, it's about those sales that apply only to Ripple, Brad, and Chris. Not to us. Not to us. See, that's the point. And again, that's the key piece that I was missing during my very last video. So thanks to all of the attorneys in our community for responding. And it's probably my fault that they didn't understand what I was trying to get to. And that's the thing. Like, human language can be sloppy. It's not the most efficient, it's not that efficient. I'll just word it that way. Human language is not that efficient. And we frequently misinterpret one another. And so when you have attorneys that know what they're talking about. If they're an attorney that wanted to ask the question that I were asking, they probably would have worded it in a more legally precise way that I wouldn't know how to do since I'm not an attorney and I just play one on YouTube. So I think that was probably part of the problem. So I was trying to ask a specific thing, and in hindsight, upon reading things, I could see why I wasn't quite getting that at first from anybody. But we ultimately did get there, and all is right in the world. There's nothing to worry about here so far as I can see. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo!